Learned magistrate took cognizance of the offence and issued process against the accused persons. The complaint was fixed for recording of the evidence. The complainants at that time made an application at Exhibit 75 for amendment. The proposed amendment was set out in paragraph 2 of the application. The sum and substance of the amendment application was that the relevant facts with regard to the vicarious liability of accused numbers 1 to 4 remain to be pleaded due to oversight. It was also stated in the said application that accused numbers 1 to 4, being the partners of the firm, are responsible for the conduct of day-to-day business of the firm, and as such they are vicariously liable. Para. This amendment application was opposed by the accused person. According to them, the amendment application was not maintainable. The application was malified. There is no provision to entertain an application for amendment of a criminal complaint. Learned judicial magistrate first class, by granting opportunity of hearing to the parties, was pleased to allow the application for amendment, holding that the amendment was of a formal nature. The application was maintainable. The proceeding under Section 138 of the NI Act is a quasi-civil in nature. It was further held that the amendment would not cause any prejudice to the accused person. Being aggrieved by this order, the accused have come before this court under Section 482 of the CRPC. I have heard learned advocate for the applicant and Mr. Rahul Mirza, learned advocate for the non-applicants, perused the record and proceedings. Learned advocate for the accused submitted that by the proposed amendment, the very core and crux of the complaint has been changed. Learned advocate pointed out that the amendment was not intended to remove any curable defect and infirmity in the complaint, and as such the order granting amendment had caused severe prejudice to the accused persons. Learned advocate further submitted that before filing the complaint, notice was not issued to the partnership firm. Learned advocate submitted that therefore there has been an inherent defect in the complaint. In order to substantiate his submissions, learned advocate placed reliance on the following decisions. Para. Learned advocate for the complaint submitted that before filing the complaint, the notices were issued to the partners of the firm. Learned advocate submitted that the notice was replied, but the amount of check was not paid. Learned advocate submitted that the complaint was otherwise in accordance with law. Learned advocate submitted that while drafting the complaint, a specific statement of fact that accused number 1 to 4, being the partners of the firm, were responsible for the conduct of day-to-day business of the firm, and as such vicariously liable for commission of the offence punishable under Section 138 of the NI Act, remained to be made. Learned advocate submitted that this was a curable infirmity and defect. Learned advocate submitted that the legal position has been well settled that an application can be made for amendment of a complaint to remove such curable infirmity or defect. He further submitted that the fact stated in the complaint and in the reply by the accused would show that no prejudice has been caused to them by granting the amendment. In order to substantiate his submission, learned advocate has replied upon the following decision. In order to appreciate the rival submission, I have gone through the record and proceedings and the judgment relied upon by the learned advocate for the parties. It is to be noted that the Code of Criminal Procedure has provided the procedure and machinery to deal with the offenders for commission of substantive criminal offences. The intent and object of the legislature in sum and substance indicate that it is an act to consolidate and amend the law relating to criminal procedure. The CRPC has provided a detailed procedural mechanism for conducting the criminal trial. It is further seen that no express provision for amendment of the pleading has been made in the CRPC like CPC. It is further seen on perusal of the CRPC that no specific provision has been incorporated to create a bar to amend the criminal complaint. The question therefore is whether the application for amendment of criminal complaint can be made and allowed by the court. If the answer to this question is in the affirmative, then the question is required to be considered and addressed keeping in mind the fact that the complaint is in respect of the dishonor of a check. The complainants in this case sought amendment to the complaint, which is the check bounce case under Section 138 of the NI Act. In order to address this question, it would be necessary to make a survey of the reported decisions of the Honorable Supreme Court and High Courts in various cases on this point. Stop.